Thank you. Please be seated. We have 3 cases on the docket today. Our first case is sitting at council table. Is our second case San Jacinto River Authority versus Ross here and ready?
Yes, Your Honor.
And then we'll be taking a short break to change out a panel for our third case, Moss versus Halsworth. All right, so that'll probably be, at least 30 minutes. You're welcome to stay outside if you want to, or watch the rest of the arguments. It's up to you. All right. And in K versus Yosowitz, does the appellate want time for rebuttal?
5 minutes, please, Your Honor.
Okay.
Thank you.
We're ready when you are.
Thank you, Your Honor, and may it please the Court. I'm Randy Roach from Martin K. This is the appeal from a final judgment in a divorce decree case. We think that has everything to do with this appeal, just as it had almost nothing to do with the trial judgment. As you know from our briefing, our contention is that the trial court completely failed in its responsibility to construe 2 key legal de novo issues presented by the memorandum of agreement, which I'm going to call an MOA, in the final decree of divorce. And that was the cap provision, the 4.25, no matter what the situation was, that had to control the judgment, and it should have controlled the trial, and it didn't. The court refused to make any ruling, despite repeated requests at multiple junctures, to construe the 4.25 cap as how it did or did not apply. Just like the membership issue, there can't be, under Nevada law, there can't be a derivative action on behalf of Greenlit LLC unless the plaintiff is a member. The divorce decree judgment and the MOA did not grant her membership status in Greenlit. And she didn't have membership status in Greenlit. The papers are quite clear. There were only 2, my client and Mr. Sammons. So unless that divorce decree was construed as providing membership status for the first time to Ms. Yosowitz, she couldn't bring this derivative claim. Again, repeated requests that the court make a legal ruling on a de novo legal issue concerning membership status. Refused, and it's instead submitted to the jury.
Yeah, there was no objection to the definition of member in the jury charge, correct?
That's right.
And so for sufficiency of the evidence, we consider charge as given?
Yes, but not for standing. Okay, our complaint is a standing complaint with respect to membership. And that's purely a judge decision, and it's legal and de novo. Okay, and that is the nature of what we briefed, and that's our issue.
So the 3 requirements that you think for standing, that you think 1 was not met?
All 3 we think were not met.
And do you think that your client met those same 3 requirements?
Oh, absolutely. I don't think there was any dispute that our client was a member of Greenlit LLC.
Did it meet the 3 requirements that you're claiming she did not meet?
Yes, and that is, it has to be unanimous consent. It has to be that unanimous consent has to be reduced to writing, and you have to sign the operating agreement. There's no dispute that Mr. K did all 3 of those things. No dispute that he was a member. Their claim, their trial and here, is that her marital interest in Mr. K's undisputed status as a member of Greenlit LLC somehow converted into a membership interest in the LLC for Ms. Yosowitz. Okay, that should have been decided at the beginning of trial. It should have been decided at least at the charge conference. It should have been decided on direct verdict, on 166, and on post-judgment motions. The judge consistently refused to shape this trial along the proper lines, and instead the result was free-for-all. Both sides got to present all of their evidence on their mutually
What was the date of the divorce?
2017.
All right, and we had K1s. There were K1s identifying Yosowitz as a member?
No, it identified her as having a 1% interest in one tax return, okay? And there was no evidence about how that 1% tax return came to be. I could offer my belief, but you don't want to hear that. What I can tell you is that the next 2 years tax returns were submitted. They showed her not at all. No interest, not even listed. So there is one, and that's it, okay, with respect to a 1% interest. And of course, that's not the 1% is not what the trial court used to value her interest in the $138 million derivative judgment, okay? Just as—
But we also have evidence in the record about 23.35% interest, that she was getting distributions of that amount?
Yes, she did. That was after the MOA. That was after the divorce. It was in the divorce decree that she got a 23.35% interest in Holdco. And as the court knows—
But she was getting 23.35% from Greenlet, not from Holdco, because Holdco didn't exist.
Right. No, she got it from Mr. K in consideration of the Greenlit provision of the MOA. So yes,
The check was drawn on Greenlet's account.
Yes, yes.
For 23.35%.
Exactly right.
Claiming that Mr. K then acknowledging she owned 23.35% of Greenlet.
Yeah. Nothing could be further from the truth, because—
Well, it's pretty clear. I mean, the evidence exists, so I don't know why you say nothing could be further from the truth.
well, I mean, we can talk about that fact and lots of others. There were 3 or 4 things that they pointed to as evidence to support an ownership position. But the real bottom line is that can't control a Nevada statute on limited liability derivative membership status, which requires those 3 things when an operating agreement exists. It can't trump that, nor can a jury finding of membership trump state law saying to be a member, you have to have these 3 things: unanimity, consent, and sign off. Those things didn't happen. And it's admitted that she did not sign the LLC agreement. Okay? She's not bound by the LLC. And in this state and New Mexico, which are relatively the same, strict scrutiny of LLC is absolutely required, because everybody needs to know who is and who is not on the hook in an LLC, who's got tax obligations, who has rights. So the fact that somebody in one conversation said you have an ownership interest, or—
Somebody, as in your client.
That's
said
right.
that,
That's right.
Right?
That's right. But it doesn't change the MOA. The MOA is a standalone, should have been decided document that's controlling when it is in a final decree judgment. It becomes a collateral attack.
Would you agree that the MOA doesn't address what happens if Holdco is not created?
It does not address that.
And Holdco was not created?
Correct.
Then we're in a hole
Well,
of what the MOA means, or how the party's interest in Greenlet should be construed or divided.
okay. In order to avoid a collateral attack, that could have been and should have been addressed in the proper time period with the family law court that rendered that judgment. Okay? It becomes a collateral attack after 6 months of not being challenged. Every judgment in this state has to be final. Otherwise, it is a collateral attack for which there is no jurisdiction in the trial court, in this court, in any court, if it's a collateral attack. So saying, I've got evidence that is contrary to the MOA, which does not give her a membership interest in Greenlit, and instead says that she is going to transfer her interest into Holdco. So she wouldn't have an interest in Greenlit anymore. It would be in Holdco had it been formed. And let's keep in mind why Holdco wasn't formed. Okay? My client sent something to her to start the formation process. She saw it and did not even look to see what it said. She sent it to her advisors and said, I don't know whether it dealt with what the MOA said or not. She took no action in a world where she admitted that it was her mutual obligation with my client to form Holdco. And she didn't do it. She didn't do anything. My client sent an operating agreement later, after the lawsuit was filed, but the only two actions to try to effectuate a mutual obligation, an admitted mutual obligation, was my client. So she frustrated, made it impossible.
But you lost on those factual arguments and
right.
are not challenging those on appeal.
That's right. That's right. Because there is a huge standing problem when she can't be a member of Greenlit. So the result of not being a member of Greenlit is that it blows up this judgment with respect to the $54 million. It blows up the $138 million in the fiduciary duty. So that's gone. If this court believes that she is a member, okay, if I lose that issue, then the cap has to be construed. And the cap issue is solid because
But
they will
again,
not,
the cap refers to something that didn't happen.
it doesn't refer.
It refers to Holdco trying to buy out her interest.
Yeah. So,
That's what it says.
right topic, right, but wrong interpretation, okay?
That's what
First,
the words say.
Well,
You just interpreting it a different way.
words are in two different places, Your Honor. Okay? Are we talking about 4B or are we talking about 3? When we're talking about the redemption process, you're talking about Section 3. Our cap is in Section 4 and 4B. And the reference to Holdco is not just Holdco, as they've told you and as the court just suggested. It's Holdco and the operating companies. That's the language in 4B. And the operating companies are a defined term, Greenlit and IP Newco. So it expressly says,
Okay, your time's up. Thank
Thanks.
you. And we have
Understood, Your Honor.
a big,
Thank you.
a big crowd here today.
Sure, sure. Thank you.
you.
May it please the court. My name is Robert Burford, and I'm represented from the Burford Perry, and I represent Ms. Yosowitz in this case, individually and derivative. I believe that you picked up on a couple of the attempts to rewrite the MOA in this case, because Ms. Yosowitz is not attacking the MOA. She's following the language of the MOA. And if you do, you'll see that each and every one of the items that had to be done, well, they weren't done. Instead, Mr. K, a few days after the divorce, decided to open up a Wyoming company secretly that he didn't tell her about until much later. And he proceeded to transfer all of the assets of Greenlit, bleed it off, the software, the code. He tried to say, well, these were just calculators. Well, we asked one of his computer people, one of the officers of his company.
So your theory on breach of fiduciary duty with respect to Greenlit is took assets, took clients.
Investors.
And the damage question is the value Greenlit would have received had K complied with the fiduciary duty minus the value it did receive. So that would seem to require an evaluation of the assets and the customers.
Yes. Well, in this particular case, since the jury found that Intera was equal to Greenlit, and every bit of evidence shows that Intera was what Greenlit would have been had Mr. K followed the MOU. He would have done the very same things with the very same assets.
We don't actually have a jury finding on that. You're just inferring that from their answer?
Yes, I am. And it was the way we argued it at the trial. And enterprise value, that's the value of a company in totality, is figured, you determine that at any given time by the value of the shares. That's what somebody came in and paid for that interest. That's a real tangible, we had very sophisticated investors in here, and that was the best measure of what the value was, what Greenland
But your
was.
expert never testified that the value of Antero was $138 million.
What he testified to is what the value of Intero's shares were multiplied by, it was a simple calculation, times the total outstanding shares. And that's what the number comes out to.
Did he testify that purchase price equals value?
No, he did not. He testified what the total number of shares outstanding were. He testified as to the price of shares. Now, interestingly, the price we had was not the most current price, because Mr. K decided, that we found out after trial, he didn't produce the value of the money raised at $22 a share, and that's in the record. After trial, he comes up and we find out that he did not produce to us the most recent capital raise. He did not produce to us his sale of part of his shares at $22 a share back to the company. So had we known that, the damages would have been much greater. So when we took...
But you're assuming that the purchase price equals value, and you don't have an expert that testified to that.
Well, effectively, that was the assumption of our expert, and then the evidence that went in, they used every opportunity, every asset. They changed the name on the door. They used the server, the software, the developers. They used the cash of Greenland to form their other companies, to get their brokers licensed.
I'm not saying you don't have some good facts.
Yeah.
I'm just quarreling with you on the value issue.
Yeah, and so the value, as determined, the best corollary for value is that Greenland, if you follow all the evidence in the case, was Antero. And it's kind of...
And did your expert testify to that?
Well, I don't think that would be a fact question. That's not for an expert to say. Antero Holdings is what Holdco should have been. Antero Holdings owns the brokerage business, and it owns the technology company. And that is exactly what was supposed to happen if Mr. K had gone through, if he had actually undertaken to do the same. It was the same structure, with one big difference. Laura Yosowitz was left out of it. Now, continually through the period after the MOA, he continually said, well, I formed these companies. There's in the summer after the MOA was signed, he comes and says, I formed a tech company and I formed a brokerage company, and now I'm going to offer you a new deal. As it turns out, he had to admit at trial, he didn't form any of those companies. They were fictitious. They didn't exist. So, when we get to what his new company became, he did not pay a single penny for any of his shares in Antero. Not one nickel. What he did is he moved all the Greenland assets over, and he got 8.8 million, whatever the exact number is. That's the number of shares that he ultimately got in Antero Holdings without contributing one penny. All he did is and we mapped that at the case through each of the transactions where additional money came in. He never put up anything because he didn't have to.
Could you address the standing argument, please?
Yeah, the standing argument, first of all, It's our belief that the issue of whether or not she's a member, in this case, is a fact question. The jury answered the question that was submitted, and there's plenty of evidence in the record to show that she was a member. As you've noted, the tax returns, interestingly, he refers to 2 later tax returns. There's only 1 later tax return that was produced. And in that tax return, she's still listed as a member. Interestingly, that tax return, which is a 2015 return, it was filed after the MOA. So he rather conveniently decided to try and remove her, but she's still listed as a member even in the 2015 return. And that's the last return they produced. So we have no corporate record of removing her as a member. And whether she had 1% or 20 or 50%, it doesn't matter. A 1% owner can bring a derivative claim. Once she has a derivative standing, and she did, there was certainly evidence that she did. Once she had that standing, she could get whatever equitable interest that she was entitled to. So we believe the jury answered the question that was submitted to them. It was factually disputed. The jury did not believe his evidence. They made the very same argument at trial that this didn't happen and this didn't happen. The record is replete. He never once offered her, hey, you need to sign this. He's got control of all the corporate records. We had trouble getting any records throughout the case, but certainly after the divorce, she didn't have access to anything. He continually took the position in negotiations after the MOA was signed that she was a member in Greenland. The MOA says that they both own, they're both members of Greenland. The Texas Family Code.
What paragraph is that in?
In what?
That says that Yosowitz is a member?
Yeah, let's look at the MO. It's in the recitals. Whereas as a currently married couple, Yosowitz and Kay own a membership interest in Greenland. And later on, when he's trying to renegotiate the deal, his lawyers say, and we've cited those exhibits, his lawyers say they refer to Laura's interest in Greenland. When they're trying to change the deal, they say, Laura, you can keep your interest, your membership interest in Greenland. His agents, when they're trying to renegotiate the deal, it's in writing. They're verifying that you can keep that membership interest. Now, we have taken all the technology out of it. We have used all of the secret sauce, all of the data. We've used it all. Well, we paid $100,000 for it after the fact. You know, he started using the data long before he had any right to. He started using the data and the software almost immediately. 3 months after he signed the MOA, he was already launching his new technology with one of Greenland's customers. 3 months.
So normally in a derivative case, you get damages that are for the corporation. So how do we translate $138 million worth of damages to Greenlit to a judgment in favor of Yosowitz?
Well, the damages to Greenland, her ownership of 50%, because what the what the family code says, if an asset remains undivided, and until they transferred that interest to Holdco, whether she's a member, automatically what would happen is the family code says, boom, you're joint tenants. At a minimum, she's legally a joint tenant of that membership interest. Because it's an undivided asset until what happens in this particular MOA.
Okay, so that's how you get to your percentage, by doing 50% of 78%?
That's correct.
How does that entitle you to recover that money?
Well, both the Texas statute and every other state to look at it says, you know, there are certain situations where we don't put the money into the company and then distribute it to the party bringing the derivative action. Because A, we don't want to put money back in the hands of a wrongdoer.
Okay, what case are you relying on for that?
There are multiple cases. I believe we cited that, for example, in Texas, there's a specific statute on the case that says that you're entitled to do this. I'd be glad to give, I think there's a Delaware case, I believe we cited one of our former claims in our motion for entry that discusses just about every jurisdiction.
Isn't there a specific statute that applies to a direct recovery in that instance?
Yes, in Texas there is.
Okay, and that statute applies here?
It's a remedy, so it does potentially
But there were
apply
some
here according to the
prerequisites.
statute.
As I recall from the statute, there were some prerequisites in order for a plaintiff in a derivative suit to recover direct damages instead of going to the entity.
Yeah, it would be just and equitable is the standard.
That's the standard. Okay.
Yeah, when it would be just.
I don't
and
have the
equitable.
statute in front of me, but I know there is one.
Yeah, it's just and the judge put that in our jury, in our final award, that it was just and equitable. And there are differing reasons, but it wasn't just don't put the money back into his hands, because he'd already terminated the company. He made it impossible to ever follow the MOA. He bled all the assets out of it and closed it down during the litigation. So why would the company need money? The company's not going to need the money because it's liquidated. Now, it still exists for purposes of a damage claim. And until she's bought out, which is the redemption rights, until she's bought out, she has her interest. So, under the standard is just and equitable. Another reason is it would be overly burdensome on potentially Mr. K if there was a large judgment, and you know, why does he have to pay himself? You know, why does he got to come out of pocket for more money back to the company? You know, this is actually more economical for Mr. K. He's only got to come up with Ms. Yosowitz's share. So there are multiple reasons under the just and equitable. Both the statute and the case law is replete with examples.
Thank you. All right, rebuttal?
May it please the court. Even if you find that she was a member of the LLC, even if you find that the damages of $138 million for Greenland was appropriate, even if you decide that she gets to collect individually for a company, in that capacity, I return to the MOA 4.25 cap, okay, where I ended. That should shut this down, and this court should render on that issue at its minimum. The most important thing, and you won't find this responded to in their brief, the very first phrase is in all cases. Next phrase, the most that she will be entitled to recover in consideration for her entire interest in Greenlit is 3.75 plus the 500 distribution. Okay? So that is the most that she can get for any cause of action, any lawsuit, any transaction, anything. It could not be broader. It was the single most important part of this divorce decree, of this final judgment, of this MOA, and any award in excess of 4.25 is inappropriate because that language specifically says to Laura. So any distributions to Laura in consideration of Holdco or the operating companies, which is defined to include Greenlit, the max that she can ever get is 4.25. That was repeatedly argued at every juncture. It was always ignored. It continues to be ignored. Okay? That is the clearest example of a collateral attack. That's section 4B. And Your Honor, your question earlier was, well, the reference is to the redemption. Again, that's in section 3. There's a difference between section 3, which is the redemption process concerning Holdco, which wasn't formed, and then 4B, because section 4 is the acknowledgement and representations provision. It has a different function, and it functions to say, we agree, she knows that the most she can ever get in consideration for her interest in Greenlit, whatever it is 4.25. You can render on that basis if we lose everything else. But we shouldn't lose membership, because there is a fundamental difference between having an ownership interest in a membership because you're married, which is community property based, and then being a member of an LLC. There are statutes that specifically require that these conditions be met, and there is no case law in Nevada or Texas, which are comparable, that says just because you have a marital interest in your spouse's membership interest, that you are then a member. The documents don't provide for her. The documents never provide for a spouse having a membership interest of any percentage. These documents, the Nevada documents and the operating agreement, never, ever, at any time stated that she was a member of the LLC. She wasn't bound because she hadn't signed it, and because you don't get to force members on, a new member on somebody. That's why you have a provision in the statute for creating additional members. None of that was followed, and that's the only way that she can bring a derivative action.
The other member,
Yes, Salmon.
he signed this MOA, right?
He signed the MOA, but the MOA
Acknowledging her interest?
never, ever, ever says that he is agreeing or consenting to giving her a membership LLC interest. The only recital, a membership
What is
interest.
the difference between the 78% ownership interest and a member interest?
78% is the LLC interest
Right.
that he had with the 22% that Salmon's had.
But
That
the
doesn't leave her
MOA
anything.
says Yasowitz and Kay own a membership interest in Greenlit.
Exactly.
78% ownership.
Yes,
Right.
that is a community property interest, and the whole point of this judgment is to end the community property marital interest. Right? That's what divorces do. No more community property interest. It's separated. What happened to her Greenlit interest? It was supposed to go into Holdco. It didn't go into Holdco because she didn't form it, they didn't form it. The most important thing I can say in my last 15 seconds is if there's a complaint about Holdco not being formed and about the interest not being assigned, that's a breach of contract claim. That breach of contract claim got tried in this case, but it's not part of this judgment. Okay? You can remand, and she can have her shot at that she won. Thank you, Your Honor.
Thank you for your interesting arguments in this case. The case of Kay versus Yasowitz is submitted, and you all can leave the table, and we'll get our next case.
clock running up, and I thought I got all kinds of time.
Yeah, it does that. It goes, starts running the wrong way. Confuses people. And you've also reserved 5 minutes for rebuttal?
I have, Your Honor.
Okay. We're giving them a few more minutes to
Absolutely.
get ready.
Yes.
Okay.
Thank you for your patience.
Sure, no.
We sort of muddled through our tables.
That's all right. Got a good time to be set. All right, we are ready when you are.
May it please the court, I'm Jose De La Fuente, here for the appellant San Jacinto River Authority on appeal of an erroneous denial of plea to the jurisdiction. As I'm sure the court's familiar, the various cases against SJRA about Hurricane Harvey flooding have mostly had different procedural timing and circumstances. Come up on a 91A on the record. Some have come up on a plea to the jurisdiction with different records, evidentiary records. But this case, however, is the companion of a functionally identical case, Medina decision by sister court, First Court of Appeals. And that case was on the same case. It was the constitutional takings claim case.
What's the status of Medina right now?
It has been decided.
Okay,
And
so
it-
there's nothing left to do.
Uh,
I mean, so when the Supreme Court ruled in Medina
Oh,
on the
Your Honor.
pleadings, and so what's happened since then?
I'm speaking to the Medina companion case out of the first court, as
Okay.
opposed to the Supreme's ruled on the 91A case.
Right.
Then it went back down on the record. It went
Okay.
back down, the record was developed. So the full plea to the jurisdiction record was developed in parallel. In the Medina case, it's on the constitutional takings claim. In Ross, this case, it's on the Chapter 2007.
And so what's the status in Medina now?
It has been decided by the First Court of Appeals.
Okay.
So-
And it's been decided in SJRA's favor.
Okay. On causation?
On causation.
It is being appealed?
It
Or
most
is it
likely.
over?
we
Or is it
expect-
over?
We expect it will be appealed to the Supreme Court.
So there's still time to appeal, is what you're saying?
There is still time to
Okay.
appeal. The motion for a hearing was denied, but there is still time to.
Okay, and your evidence in this case on causation, is it the same or different from the evidence in Medina and Gonzalez?
It is.
And Ackley?
It's different than Gonzalez and Ackley.
Okay.
Gonzalez and Ackley were on much lesser records. It
Okay.
is functionally the same as in Medina.
Okay.
And this is important. It's functionally the same parties. There were 171 plaintiffs, and all but 7 or 8 overlap in both cases.
Is it the same controverting evidence in Medina?
Yes, Your Honor.
Same affidavit?
Same affidavits. I mean, with again, some slight differences of, and I'm talking about these handful of plaintiffs here and these handful of plaintiffs here, but on all the relevant evidence of causation, it's the same evidence.
So Dr. Bedient's affidavit was before the court?
Correct, Your
Okay.
Honor.
And is there a difference in the standard for constitutional taking and Chapter 2007?
Yes and no. So constitutional taking, again, well fleshed out by the court in Medina, and the basis for their finding of no liability was that SJRA did not commit a taking because it didn't cause additional flooding greater than natural conditions. That was a substantial factor in the overall flooding experienced by plaintiffs 40 miles downstream who are experiencing a confluence of resources, a confluence of sources. Chapter 2007, if we look at the Venn diagram, there are 2 types of taking under Chapter 2007. The first one is a restatement of a constitutional taking claim.
Right.
Well, if you decided one, you decided the other. The Venn diagram includes that. The second is something that falls to a lesser standard of than the constitutional taking, but is a producing cause. So there we go. It takes the same causation standard of at least a 25% reduction in property value. So either way, causation is the gate. Under both types of taking under Chapter 2007, causation is the common gate, and causation in this circumstance, again, remembering we know what the standard is, Medina tells us and Bragg tells us what it is for a flooding taking case, where you must have flooding in excess of natural conditions that is a substantial factor in causing the flooding. In the 2007 type B taking, it must be a producing cause, which producing cause, Texas Supreme Court, Ford Motor v. Ledesma, tells us producing cause is a substantial factor in causing the damages. Bottom line is, the substantial factor component is always a component of causation. Now I know that appellee has arguments about, well, but any trespass at all can be a taking. Look at Cedar Point Nursery, etc. That's only when there's one factor. Like in Cedar Point, it was one agency setting foot on the land. There is no, is it a substantial factor or not? It's the only factor. In the case of Bragg, in the case of Medina, you have massive flooding. You have Mother Nature delivering a flood. And you have, particularly in Medina and companion cases about this authority, conflicts.
So you said the evidence in Gonzalez and Ackley was different?
Yes.
And so we cannot rely on Gonzalez and Ackley in answering the question as to whether or not you met your burden to disprove causation as part of the plea?
On the record, no. On the standard, yes.
Okay.
They each state and apply the standard correctly. They apply it to different record evidence. And to talk about what the record evidence is or isn't here, again, it's important to understand, as Bragg tells us, you must exceed natural conditions. Mother Nature was delivering a giant flood heading down the West Fort Cinderella River. Mother Nature has full right, title, and interest in that flood. It hits SJRA's dam. SJRA passes through some, not all, some of that flood at a lower rate than it received it. It did not magically take right, title, and interest in that flood that Mother Nature delivered. It might if it exceeded what Mother Nature delivered, which is exactly what happened in Bragg. Bragg and Wickham, Waller, and Hughes, which are, again, really mostly about this authority and this dam, Wickham particularly, give us the how to do it wrong and how to do it right. If I receive a flood at this rate and I amp the rate up and release it, then I'm probably going to be on the hook. And they did that multiple times in Bragg. In Wickham, if I receive a flood and pass through no more than what was received or less, particularly when there's a confluence of sources, which triggers our substantial factor analysis, I don't cause a flood. And that...
Beaumont says that. Our court hasn't said that yet. Right?
Your court has not said that because you haven't reached the question on the record. You've only looked at it in the 91A context.
Right. Let me ask you, if I could, about the exclusions in Chapter 7.
Yes, of course.
So one of the exclusions you're relying upon is this good faith belief exclusion. So
Yes.
Are you aware of any cases that have examined that exclusion with evidence?
We are not. We've had nice conversation back in our conference room, said, wow, this is an interesting question.
And so my question to you is, because of the words good faith in this section, are we to apply the good faith test that applies in official immunity law, for example? Is that the standard that's going to apply here, where you have the burden on the movement or on the defendant to demonstrate that a reasonable official in the river authority's position
Sure.
could have believed that releasing the water when and in the volumes that it did was necessary, and then the burden then shifts to the claimant to present evidence that no reasonable official could have thought that, and so forth, as you would under immunity law.
It might be the standard, and if it is, Your Honor, the good thing about that is the evidence in this record clears that standard by far.
Okay, what evidence in your affidavits attached to your plea would meet that standard?
There are three things that the River Authority did. It developed a gate operations plan. It listened to what it should do for the gate operations plan. It developed that plan with engineers, and it followed that plan. And it did so with the intent, and this is undisputed, with the intent of avoiding a dam failure, which is exactly what the exception is about.
So you're going with the second exception, not the first? The first exception says reasonable good faith belief that
Correct.
the action is necessary to prevent a grave and immediate threat to life or property.
Yes,
Okay, you're not going on that one, you're only going on the second.
we're going on both, Your Honor.
All right.
We're going on the second as well.
Well, where is a testimony in your affidavits to that effect?
The reason that SJRA developed this plan is it was told by engineering practice and by the ultimate experts, 3 people in black robes, and granted they're in Beaumont, but they still wear the black robes, that you avoid causing a flood if you operate your dam in a way that does not exceed the outflow. The max outflow does not exceed max inflow. And they further were
So
told
you
by
developed the GOP for that reason, for the max inflow, the peak inflow versus peak outflow.
that was,
issue.
well, the key element of it was that reason. The reason you have a gate operations plan is so your dam doesn't fail. That's why you have a gate operations plan. And that was undisputed. By the way, Professor Bedient admitted that you should not let your gates be overtopped. No prudent operator would do that. And you should not let your dam be overtopped. No prudent operator should do that. So any plan you have must be with that in mind. And the reason you have that in mind is so you don't fail as a dam.
Okay.
And there are myriad ways you can do so in between, and you can look backwards in time and come up with maybe I could release 20 CFS less, or this
All right,
and the other.
so you developed the plan, you followed the plan, and then what else? Is that it for
That's it.
meeting your burden?
That's it. Well, and that the purpose of the plan was made clear in the record and was undisputed. I mean, the plan was it's not incidental that the plan saves the dam and saves lives. It's the reason why you have a gate operations plan.
Okay.
Thank you. We'll have time on rebuttal.
Chief Justice Christopher, Justice Jewell, Justice McLaughlin. SJRA's design and operating procedures evolved over time. Because of those changes, during Tropical Storm Harvey, SJRA released more than 50 billion gallons of water during a 24-hour period, reaching an outflow equal to the water flow over Niagara Falls. The result of that was that water was not contained within the bed and banks of the San Jacinto River, the West Fork, which was the limit to what they could use the San Jacinto River for in discharging water based on the permit that they had. As a result of that amount of water coming down, it exceeded the banks and invaded the property of plaintiffs, people who were along the side of those banks, and instead of it going down in the river and the banks and the bed, it came over that and flooded. And as a result of that, they violated their permit, they invaded private property, and this lawsuit resulted. Now, this lawsuit,
Do you agree that the record is identical to Medina?
no, it's not much different, but it is not identical.
Can you tell us the differences?
Well, there are a couple of things. One is that, remember that in this case, this is a statutory case. And so the evidence and the discussions about the evidence relate to the statutory parts of this as opposed to a straight takings case under the Constitution.
Why is that different for causation?
Well, there are a couple of reasons. One, let me be clear. We don't agree, obviously, with what the First Court of Appeals did in terms of applying a substantial factor test. And quite frankly, no inverse condemnation or any condemnation case has ever done so. that is applying a negligent principle when you have multiple parties and you're trying to allocate and you're determining whether something is so attenuated that it can't be involved. I mean, I have great respect, obviously, for the judges in that court. I just think they got that wrong. And so I don't think that case applies, and I'm happy to talk about that at length. But in this case, if you look at, and it's important to look at what the statute is, and I'll give you just there is a question that you're going to have to think about and deal with. As you recall from, I'm sure, all of the cases that you have read on condemnation and handled, it says that a taking is a question of law. Not according to statute. According to Chapter 2007, a taking is a question of fact. So you have to look at everything that is done with a different perspective because it talks about a question of fact. Second is, the Constitution doesn't deal with or doesn't talk about this substantial factor, but the statute talks beyond what the Constitution, state or federal, does. And the statute says that a taking means a governmental action that affects private real property in whole or in part, or temporarily or permanently. Now that is different than the idea of a substantial factor. You've got two things put in here very clearly that are different. Whole or in part, temporarily or permanently, and definitely does not include, has to be a substantial factor. Now, if you look at the evidence in this case, what Dr. Bedient has said is that the amount of water from Lake Conroe that got on the plaintiff's property was 2 to 4 feet downstream. Now, that is a physical invasion, whether there's other water there or not. That is a physical invasion.
Yeah, but did he say how that affected the property owners?
Well, okay, the answer is twofold, yes. One is, he said, that means that the flood itself was exacerbated. There was more flooding. Second, the flow comes faster. And so he talks about the flooding effects of the water from Lake Conroe.
And I understand that. My question is, according to what the River Authority presented, the discharge from the dam wouldn't have reached 59, Highway 59 until like August 28th or something, okay? And at that point, according to what the authority presented, the water level above mean sea level was, 20 feet above at that point in time? Or 14 feet? I forget what the number is, but it was substantially above the normal level and so when the release from the dam hits that point when it's starting to enter Kingwood, I'm assuming is when Dr. Bedient says that water elevates the flood level 2 to 4 feet. And so what effect, I'm trying to understand what effect that has and what's in the record.
And it will vary from property to property.
Right.
If the water beforehand was 2 feet below and now it's 2 feet above, then it has.
Okay, but that's my point. Is there evidence in the record about at what point in time each plaintiff's house flooded? Was there evidence that the flooding didn't occur until after August 28th? If a house is already underwater by 4 feet, does it matter if it's increased to 6 feet? And
the answer is yes, for two reasons. First, regardless, there are two kinds of damages for inverse condemnation, okay, or a flowage easement. One is the decrease in value as a result of the flowage easement. So simply putting water on there, whether it affected a piece of property in terms of repair or replacement, doesn't matter on the diminution in fair market value. And that is a damage that you would get in any condemnation case, you would get in any flowage easement case. And remember, they got flowage easements to a limited extent. they paid $150 an acre, there is obviously a value, and that protected them. Here, they chose to not implement this flowage easement until they flooded it, which creates the flowage easement, which is what occurs over in Addicks and Addicks Barker stuff. Once they actually flooded, all of the other things that they've done give rise to the taking. So putting the water on there has a damage regardless of the physical damage.
Even if water was already there.
Even if water's already there, because it is the physical invasion. And that's why I say go back to the statute, and what it says is, one of the specified governmental actions is an action that imposes a physical invasion of private real property.
Right, but the idea of substantial factor is incorporated in the idea of causation. So whether it's proximate cause or producing cause, the act still has to be a substantial factor of the damage, right?
And the answer is yes, but there is a difference. Again, we're now coming up on 8 years of fighting on the plea of the jurisdiction, so we haven't fully completed the record. But the difference is that you have whether there is an inch on there or 2 inches, you can have flooding and it has an effect, no question. If you have what is now a flowage easement, that has a permanent effect on the value of the property. And that's what, what we've been seeing. We've already seen the result of that out of part of the litigation over in Addicks Barker. Once the liability and damages was concluded, it now has a flowage easement, and it's now a part of the record. It's not just that something has flooded before, and there is a difference, value-wise, between something that has flooded and something that has a permanent flowage easement on it, where they have the right to put water on this in perpetuity. That has a different effect on the value. Now, the other part is, nobody has yet gone in on each of these and said, because there's an extra 2 feet here, there is additional flooding. I know that it does, because if you have 6 inches or a foot of water in a house, and it's there for a period of time, as compared to 4 feet, you get more damage on the sheetrock because it wicks more up. There's more damage that has to be done. So, I mean, we know that those kind of things happen. Those haven't been developed, but the fact that there is water there doesn't mean that there hasn't been damage. And with respect to the statute, again, there is
Again, going back to substantial factor, which is an element of producing and proximate cause, if the flooding is, 2 foot, don't we have to know whether the flooding is 2 foot 1 inch or 2 foot or 2 foot to 4 foot before it's a substantial factor?
Good point. First, I don't think that's the test. I mean, I don't think substantial factor has anything to do with inverse condemnation or condemnation cases in terms of the cause of action. There is no case that says that. When they talk about it, they talk about is it a governmental action, and that's what the statute says, a governmental action that affects private real property. There's nothing in there about substantial causation or substantial factor. And it is different if you look, I mean, y'all wrote a wonderful opinion, although y'all were on opposite sides, as I recall, in Critical Path. There was only, I think, 81 pages long, and about 30 of those had to do with substantial factor. And Justice Busby pointed out the difficulty that people have in applying this, and there was a difference there between a superseding cause and, I mean, the fact of it is, those are tort-related concepts. That has never been applied, ever been applied in an inverse condemnation case. The only place it might, and I'll say again, nobody has cited a case to this effect, and I don't believe there is a case that says that you apply it even to the physical property damage. Now, you've got to show what your flooding did on the physical property damage, but that's things that we have to do all the time. I mean, so I think for purposes of this case, it is not. Now, let me focus on something
ordinary
else.
proximate cause principles do not apply
They
to
do not.
taking.
I mean, if you look at, for example, they cite Hart Bluff. Hart Bluff was a regulatory taking. It actually refers to, I want to say Kale. State versus Hale, which makes it clear it was a question of is there an action that you can trace to it? That's the causation that they talk about. And I'll see if I can find that quote here in just a second. But if you look at Hartsbluff and the State versus Hale, look at those two cases, it is clear they're not talking about proximate cause in the way we frequently talk about it in tort cases. So I don't think that applies. But
So there's a difference between liability, the taking, and damages.
there is.
So
and
you would have to show proximate cause of damages, but you don't have to show
Well, you have to
that
show-
same substantial factor for the taking.
You have
is
to
what
show
your
cause,
argument is.
and they use the word proximate cause, but when they apply it, they don't see, in none of the cases apply it in the same context. And certainly, again, you're not talking in takings cases, it's what the governmental entity did with respect to the property, not what anybody else does. There's not a contributing causation, there's not an allocation of responsibility. And in this case, again, keep in mind that the decision on how to build this dam and how to operate it was made with full knowledge that if they did it the way they chose to do it, they were going to flood people downstream. That was clear. If you look under tab 2, you're going to see a letter in there where the engineer who is doing the design work talks about the importance of flood control as a part of the enabling statute, and that that the maximum flood will be 213 feet high, and they want to build it so that they can hold water to 217 feet high, so none is dispersed. So, I mean, that is how we got here. But let me get to a point that I think is really important. On this kind of plea to the jurisdiction, and first, this is not a plea to the jurisdiction complaining of the pleadings. The Supreme Court has already said the pleadings are fine. And Mr. Helfand, when he argued this, said, we're not complaining about the pleadings. So, looking at the pleadings and saying, for example, there's nothing in there that the Supreme Court said you need to say substantial factor, nor is there anything along those lines, nor is it in the statute, which means you would be adding that to the statute. But the second part of that is, if it is a jurisdictional fact, and Bland, if you want to really dig into something that'll make you go, your eyes sort of glaze over, trying to figure out what is a jurisdictional fact versus merits, because Bland says you do not get into the merits of the case unless it is entwined with the jurisdictional fact. So what is a jurisdictional fact? Well, Bland gives several examples, but it's not the merits. Here we're talking about the merits. Third thing is that is very important. On a plea to the jurisdiction based on evidence, they have the burden to conclusively negate the issue. Not just have facts about it, not just have questions about it. And clearly, Dr. Bedian gave very clear information. For example, they say, well, you've got to show what would have happened if between no dam and what happened here. Dr. Bedian did that, and he showed that there was additional water on these properties than if there was no dam. So he actually did precisely what the would. And do you know, it's amazing what happens if you go back and actually read the record. I went back and saw that, and do you know what the issue was in this case when we first argued? Is there any water from Lake Conroe on the property? That's what the argument was. The argument was that the plaintiffs have to show that some water from Lake Conroe is on the property. And that is something that nobody disputes now, that Lake Conroe water got on the property.
Let me ask you a question, if I may. With regard to this peak inflow versus peak outflow standard, if we were to agree with you that that test doesn't apply or wasn't met or whatever, would we be issuing an opinion that conflicts directly with Wickham and like cases that have ruled in favor of the River Authority on that basis?
The answer is not as to Wickham, because Wickham is a summary judgment case, and that decision was based on expert evidence that was not controverted. It wasn't based on some legal decision that this would protect dam operators. It was done because there was no controverting evidence in that case. In
Right,
this,
but-
in
but-
Brocker, in this case,
But
this
causation
court
was-
said that it doesn't work. Dr. Bedient has given testimony, they say that is.
Brocker's different because Brocker was a pleadings analysis.
It was, but they raised, look, they have raised Wickham, they raised Wickham when they filed a motion for, an intervention, an amicus brief on the Gregg case. And the Supreme Court has never adopted that. Gregg didn't adopt it, it's been cited.
I know that, but you're
I'm
asking
saying-
us
I'm
to say
saying
something that's different.
If you're saying, what happens, would it be contrary? The answer is yes, if you say anything. What everybody else has done is just ignored it. But Dr. Bedient points out that the amount of inflow and the amount of outflow is something that's part of what dams do all the time, because it changes the flow of the water from the natural river to having a reservoir, and actually things move faster and various things occur. And he said, and so if you look at the original operating procedure, it was that you couldn't do more than 75% of the inflow, so long as you're not going to flood downstream. They had that in there. They took that out. That is not something that was a part of what Wickham talked about, but that is in fact what happened when they went to the 2010 and the 2017. They took out the fact that that anything they released would be for the purpose of not increasing flooding downstream. So Wickham is also wrong. If you look at the calculations, they say that it was 130. That's the reason, and the reason for that is because they take into consideration rainfall, which will cause a spike. In the earlier operating procedures, they said don't take that into consideration because that gives you a false reading, that gives you a false high. Here they had a false high. And what Bedient says is it is roughly, in terms of the actual inflow and the actual outflow, roughly about the same. It's about 80 and 79. But that doesn't have anything to do with is it safe to release. And Jace Houston gave a statement that it would take a long time to release water from the dam, so that he made sure that that water didn't come out of the banks, and so because he knew what his limitations were. That has nothing to do with some sort of moment in time. And stop and think about it from a physics standpoint. And I know I've gone way over, and I apologize, and I'm taking advantage of the question you asked me.
And I'm about to cut you off. Go ahead.
What's that?
I said I'm about to cut you off. Just give
Well, please
one
don't.
minute, 1 minute sum up.
If you have an inflow that is 130 for 1 hour, and then it drops down and it is much, much less. And then you have an outflow, and you raise it to 80,000, and all of the other inflow here is under 80. Have a peak, everything is low. Now you're doing it out at 80,000 cubic feet per second, 600,000 gallons a second. There's no correlation that you're somehow doing something safe. Water is going to come in there. In the 1994 flood, the peak inflow was 180,000. They let 33,000 out. It's not, those two things don't necessarily go hand in hand. In fact, they don't go hand in hand. What you have to do is hold the water until it is safe to allow to send it downstream. And that's going to be affected by how much flooding there has been downstream, and you keep up with it. That's what the original plan.
If the dam broke, would these houses have still flooded?
I'm sorry?
If the dam broke, would the flooding have been the same or worse?
Oh no, if the dam broke, absolutely it would have been worse. And speaking of that, just be clear, there was never a question of overtopping, and all the evidence is that it was working just fine. In fact, the gates were they were at 214 feet above sea level, and the water was never above 206. There was never a concern of overtopping. They never said that. In fact, the dam operated exactly as they wanted. The reason they opened the gates was to protect the liability that they would have if they went beyond the flowage easement behind the dam, and did that by putting the downstream at risk. They basically made the downstream suffer to try to protect themselves because they only had a 207-foot flowage.
Okay, thank you.
And I could take another 5 minutes.
Yeah.
Think of it much.
I think on both sides could probably take an hour. But maybe another day.
I was going to tell you a war story, but I thought, this is not really the time for that. Thank you.
Thank you.
May it please the court, I'm glad that Mr. Higgins brought up the language of Chapter 2007. I'm also glad that he didn't read to you the part that included the causation standard. Because Chapter 2007 does say it's an action that affects private real property in whole or in part, or temporarily or permanently, in a manner that would be compensable under the Constitution, in a manner that is the producing cause of damages. Causation is always a standard. And of course it is, because one of our rules on taking is the
But
government.
producing cause of damages is different than producing cause of liability, which is what you're sort of arguing for here.
Yes, Your Honor, because the damages and the liability are intertwined. You're not liable unless, under Chapter 2007.
But your proof here is not that this house got 1 foot of damage, and because of our release, it has 1.3 inches of damage, and that's not damage. That's not your proof here.
No, Your Honor, it is not. Our proof here is in line with what Greg told us.
No, and your proof is not even house by house, not substantial. I mean, you have this argument that it has to be a substantial flooding, and your proof is not that.
Yes, it is, Your Honor. And here's the problem, and I'm urging the court not to bite on the red herring. The red herring is not that SJRA has ownership and liability for every drop of water that passes through its dam. Mother Nature dropped a massive flood on the West Fork San Jacinto River. That flood was accompanied. It passed through the Lake Conroe Dam. That is Mother Nature's flood, and it's always Mother Nature's flood. The entity only causes the flood if it increases it above natural conditions, and that increase is a substantial factor.
Okay, so that's liability. You're arguing that on liability, that substantial factor.
Yes,
not on damages.
As to causation. But it has to cause the harm.
Aren't they the same?
Yes.
But
It
you
has-
haven't proved that.
The
You haven't
damage-
said this house, flooded to 2 foot, and with our water, it went to, 2.5. So
What
it's not a
SJRA has
substantial
proven
factor.
is the negative. It's proven that it didn't pass any water above natural conditions downstream. And I mean, Mr. Higgins mentioned there were 50 billion gallons of water that passed through Lake Conroe's dam. There were 816 billion gallons of water downstream of the plaintiff's property. And I mean, Greg told us in causation context, in no uncertain terms, it is not, you cannot support a finding of taking even if reservoir releases contributed to the volume. The only claim here and only evidence you have here is that reservoir releases, not in excess of natural conditions, contributed to the volume. Which the answer is, of course they did. Nobody's running from that. Why would you? Mother Nature sent a bullet downrange. It passed through us. It hit the people downstream. There's no question that happened. But SJRA did not fire that round. And the only way it would be liable is if by some reason that bullet passed through SJRA and SJRA accelerated the bullet. That's causation. That's why it matters. And that's why the substantial factor test, you cannot run away from it because it's inherent in causation across the board. Proximate, producing, no matter what, it is the standard. And it was interesting that there's a complaint about construction of the dam and what more you could do. Let's be real clear. This case is, as most of the cases against SJRA ultimately have been, you didn't do enough to prevent flooding. You could have operated the dam differently and released a little less here and there. There's no natural disaster. I cannot look back in time with the benefit of hindsight and say, maybe I could have done something different. The Supreme Court in Kerr told us you don't do that. What the standard that the plaintiffs are arguing for here is if the water passes through your dam, you now own every drop of it, even though it's Mother Nature's water. You now own it. And that violates the rule that Kerr told us, do not make the government the insurer against all manner of natural disasters. If that's the rule, there is no way to operate a dam in the state of Texas or anywhere else. You will always be facing a takings claim and frankly be found liable because you passed water through your dam. And I could argue you could have done more. We could have sent a guy out with a 5-gallon bucket to scoop water out of the dam and hold it in his car. That would have reduced it. That's not the standard. They're arguing for a one-molecule standard that was rejected by Gregg and importantly, very much rejected by by Medina. Medina, they observed, commenting on Gregg, that the court said repeatedly the landowner is required to show more than the simple fact that water from the reservoir ended up on his property. We have demonstrated that, yes, water from the reservoir demonstrated on your property and landed on the property, but nothing more than what Mother Nature delivered.
Thank you.
Thank you.
Thank you for your arguments in this case, and we will take a brief adjournment for our third case.
All right, everyone, please be seated. Okay, we are back in session. Everybody's nameplates correct. All right. So we have one last case on the docket today, the Taylor Moss versus Holsworth case. And the appellant, you ready to go? You're reserving 5 minutes, is that
Yes,
right?
Your Honor.
Okay. And
May I please?
appellee's ready to go? All right. Okay, then you may proceed.
Thank you, Your Honor. May it please the court. My name is Andy Taylor. I represent both appellants, Taylor Moss and his trust, the TCM Trust. I'm going to cover 3 topics today, and I'll just mention them, and then I'll argue under each topic. The first topic that we contend is that we withdrew consent to an agreed judgment before rendition of that judgment. That's first point. The second point we're going to argue is that there was a tape recording over an hour long of the grandmother whose mental capacity was at issue in the trial, and it was not admitted, and we are going to demonstrate that it should have been. The authentication requirements were met. The third thing I want to cover has to do with the motion to recuse. Thankfully, depending on how you rule on the first issue, you'll never reach the motion to recuse, and I'll explain why. So I think that's probably going to fall away. As to the first argument, that we withdrew consent before rendition of the agreed judgment, there are 2 Supreme Court cases that I would ask for you to have in mind as you ponder this. The first one was decided just last year. It's Baker versus Bizzle. That case, decided by the Texas Supreme Court last year, is a divorce proceeding, and what happened there is the judge sent an email to the lawyers for the parties. And the question that the court was looking at is that a rendition of judgment? And the court said no, because it wasn't done publicly. A rendition of judgment has to be a public pronouncement. It can't be signing something in the privacy of your office. It's got to be filed in public.
And in our case, the rendition was in public in a hearing.
That's a critical, I'm glad you asked that question, because what we're going to demonstrate, hopefully to your satisfaction, is that what happened in open court was not an oral rendition. And I'll get there in just a second. So the Bizzle case says that it's got to be public, and there's 3 ways to get there. One of them, Your Honor, as you just mentioned, is an oral pronouncement by the judge in public. That's one of the ways to get there. But what this judge said in public during the hearing on January 11 of last year, he said, and I quote, "Motion for entry is granted." And my opponents are going to say that was a rendition. Here's why that's wrong. First off, the motion that was granted was filed a couple of days before. I believe it was the 8th or the 9th of January. That motion is in the record, and it's at 14 Clerk's Record 12,006. And that motion attaches multiple proposed agreed judgments. There's an Exhibit A, there's an Exhibit B to the motion. Exhibit A has 3 subparts. The first one is a settlement agreement. And that settlement agreement's got proposed judgments attached to it, two different kinds. Exhibit A also has a Rule 11 agreement, which also has proposed judgments attached. And Exhibit A, thirdly, has a promissory note, a secured promissory note, which again has judgments attached. So that's just Exhibit A. We've got 3 different documents with 3 different sets of judgments attached. Exhibit B is a proposed agreed judgment. So now we have another judgment that has been proposed in the motion. So when the judge said motion for entry is granted, the Supreme Court requires it to be clear and conspicuous on exactly what was rendered. And you can't know, because there's multiple judgments in the motion that got granted. There's a deeper problem for them, Your Honor.
But on January 11th, did both parties leave under the understanding that the trial court had granted the judgment for that, not one of the other ones, but the final judgment.
I would think not, but let me tell you first, I wasn't there. I didn't become counsel until this summer, so I can't speak with personal knowledge. I wasn't in the room. But what I can tell you from reading the record, which is what you guys will be doing, is reading the record, is that when he said motion for entry is granted, he immediately then said, before I sign your order, that's a quote, what order is the judge talking about? Is he talking about an order granting the motion for judgment? Is he talking about an order of two different lawyer groups that were asking to withdraw? Is that the order that he was talking about? There's no way to know which order he was talking about. And then, what really nails it down, Justice McLaughlin, is that there is a discussion, and I'll tell you where to find this in the record. This is the motion itself is, of course, in 14 CR, but the actual hearing is a reporter's record, and it's transcript 17, pages 3 through 22. So if you look at 3 through 22, which is the motion, the actual hearing, there's a discussion after he says, before I sign your order, about do you have a clean copy of something you want me to enter? And they hesitate and they say, well, we think we filed something before the hearing started, which was true. If you look at the record, they filed yet another proposed judgment before the hearing. And then they said, we don't know, oh, wait a minute, that may not be the right one because there are two different agreed judgments in this case, Judge. We don't want you to get confused, so hang on, let us check. And then one of the lawyers says, it's all in the record, oh, we did upload something. Has it been accepted? And he looks and he goes, yeah, I see something that's been accepted. And then they interrupt and say, that's not the right one. I'm sorry. We're going to have to get the right document in front of you. And he says, my clerk is out. Can you just email it to me? And they said, well, given the environment here, I'd rather not just email it to you. Can I e-file it? And he said, well, just email it to me and copy everybody. And then the hearing ends. And then sometime after the hearing ends, they email the judgment. And then he signs that judgment, not on the 11th. The document says he signed it the next day on the 12th. It didn't get uploaded until the 18th. And so returning to the Bizzle case, they say there's 3 things that have to happen to reduce a decision of a trial judge to a appealable judgment. Number 1, rendition. Number 2, signing. Number 3, entry. Now those 3 legs of the stool could occur all at the exact same time, and often do. So a judge will be in his office and he'll decide, okay, I'm gonna enter an agreed judgment and I'm signing it right now, uploading it, and boom, the clerk accepts it, it's all done flawlessly. But it's oftentimes not that way. Rendition can occur before, and so I return to your key question, because this makes the appeal either a winner for us or a loser. Is what happened on the 11th when the judge uttered those words where he says, motion for entry is granted, was that rendition as a matter of law? And here's why it's not. It's the second Supreme Court case I alluded to. The second Supreme Court case is Naaman versus Grider. It was decided 20 years earlier, 2004. And I'm quoting, the Supreme Court said, an order that merely grants a motion for judgment is in no sense a judgment.
All right, let me interrupt you and get back to your point about withdrawing consent. So as I understand it, there was a settlement agreement reached back in November or whatever of 2023 during the trial. That settlement agreement contemplated some potential judgments in the future depending on whether or not your client performed certain things, right? And then, in fact, one judgment had been signed by the court and your client had done things under the agreement. And the second judgment that was signed and then entered, whenever, didn't happen until after terms of the agreement had already been performed. And why do you have the right to withdraw consent
So,
at that point?
right. So the breach of contract is the answer. So
Okay.
if you have a settlement agreement and you withdraw from the terms of the settlement agreement, that can expose you to a breach of contract claim. But it doesn't entitle you to an agreed judgment that's been undone before rendition. That's the point. And so here, because what happened orally was not a rendition, signing the judgment on the 12th or sometime thereafter isn't a rendition because it wasn't public. What was public is when it was uploaded on the 18th. So the 18th is when rendition occurred. We beat that by 1 day. Before I sit down, the other point I want to make, and I'll amplify.
So explain to me again why you have the right to withdraw consent before the 18th.
Because it's an agreed judgment. You can't confuse consent to a judgment and consent to a settlement. If you breach a settlement, then you can be sued thereafter. They can amend a claim, sue you for breach of contract. That would have to occur before a judgment could be entered for breaching the contract. But
So you're
here,
saying your client is free to breach the settlement agreement and then withdraw consent to the,
they're two separate things.
but he's withdrawing consent that was a specifically contemplated part of the settlement.
Well, but understand there's two legs to this. So there's certain things had to occur before the end of December of 2023, and if they did, his maximum responsibility would be $5.5 million. But if he didn't do those things, which he didn't, then his maximum exposure would be almost $10 million in the form of an agreed judgment. That agreed judgment,
Which was agreed to at the same time he agreed to the settlement.
which answers the question that on remand, if you void the agreed judgment because we withdrew consent before rendition, if you void that judgment, then the trial court will decide what to do with a future judgment. They would need to amend their pleading and sue us for breach of contract. And they could do that, but there'd be fact findings, there'd be a jury. That's what the case law says.
I mean, it seemed to me like the whole part of the settlement agreement was contemplating that your client would breach, and that's why they agreed to the judgments.
I think my client desperately wanted to comply with that first part, but he couldn't come up with the funds.
Oh.
And so, he couldn't do it. But the point of the matter is we can't confuse apples and oranges. The agreed judgment that was finally filed on the 18th was undone by the withdrawal of consent. So then it goes back to the trial court. The last point is the reason why I've raised this issue about the tape recording, because you may say, well, wait a minute, if we're going to vacate the agreed judgment, send it back to Judge Semino for consideration on what to do on remand, why are we talking about a tape that happened at trial? It seems like a gratuitous advisory opinion. Why are you suggesting that, Mr. Taylor? And the answer is because what the other side has said in their briefing to you is that if you vacate the judgment, as we're requesting, they're going to ask the judge to enter judgment on the jury verdict. The jury verdict was based not on this tape. This tape was not admitted. And this tape was on an iPhone. Back when the case was decided, Seymour versus Gillespie in 1980, I was graduating from high school. Back then, when you're tape recording, it'd be like some sort of an old tape recorder. It's not a sophisticated device like an iPhone. And so when you look at the 7 standards about what do you have to do to authenticate, we met them in spades.
And just to stop you just for a second, because I haven't quite gotten that far. If, say hypothetically, if we do say, okay, he withdrew the Rule 11 consent, the jury still unanimously found Moss engaged in fraudulent conduct and all of those things. And that is unanimous. And so how would then the settlement agreement reopen to bring up
Right.
the
So
grandmothers?
I think that question's posed to my opponent because they're going to have to make a choice. If you remand and vacate the agreed judgment, as we say you should, then they're going to have to make a decision because they're the plaintiff. If they want to amend and go to the judge and say, they breached the agreement and we want you to find they breached the agreement. We want extra damages on top of what's happened in the past on that agreement breach. They can, and we're gonna have to defend it. But if they choose not to, then they've already said this in their brief. They're gonna go to Semino, Judge Semino, and say, we've already won the jury trial. We want you to enter judgment on the jury trial, not on agreed judgment. And they're free to ask that question. What I'm asking this court to consider in the interest of justice is to opine on the authenticity of our attempt to put the tape recording in evidence, because if we met the 7 standards, which we clearly did as our briefing demonstrates, then he can't simply enter judgment on the jury trial because it didn't consider an hour and 15 minutes of the grandmother showing she was lucid and wanted to do exactly what she was doing, as shown by a tape of her. That is so valuable, you can't overcome that. And we were entitled to make that presentation. And so I see that I'm out of time.
Thank you, Mr. Taylor.
Thank you.
We'll hear from you on rebuttal.
Good afternoon, and may it please the court. You heard nothing in Mr. Moss's argument about the January 12th signature date on the written final judgment. And that's because what this appeal is really about is whether parties like Mr. Moss will be allowed to get out of their settlement agreements by making baseless accusations against trial judges for backdating judgments. Let's be clear, Justice McLaughlin, you asked questions about phase 2 of the trial. Mr. Moss has obtained the benefit from this settlement agreement by forever dismissing this jury that was about to determine not whether to award us punitive damages, but the amount. Mr. Moss, it's no surprise he wanted to enter into that agreement. There were 70+ pages of adverse jury findings based on claims brought by his mother and his aunts after he was caught raiding the family trusts. The Bumstead family wanted finality, and as you mentioned, Justice Jewell, anticipated that Mr. Moss would violate this settlement agreement. So there were 2 paths forward. Mr. Moss did not comply with the settlement agreement. There was one judgment to be entered in that circumstance, the one that Judge Semino signed on January 12th of 2024. What we are asking this court to do in this case is to send a message to bad actors. They cannot breach your settlement agreements and protect Texas trial judges from being in the crosshairs of such accusations about backdating signatures as Mr. Moss has made in this litigation as a get out of settlement free card. I want to make 2 points in my argument today. The first, talking about the waiver of the right to appeal, and second, to address Mr. Moss's rendition signature date. On the first, I want to be clear about what we are asking for. Since April of last year, Mr. Moss has sought 14 different emergency proceedings in this court and the Supreme Court. I think that's an indicator of what's to come after this court's decision. We want the Supreme Court to have both grounds that this court's precedent clearly establishes with regards to the waiver of right to appeal. One is based on Mr. Moss's inaction at the motion for entry hearing. The other is based on Mr. Moss's actions in contractually waiving his right to appeal. The inaction ground is exemplified by this court's holding in DHI holdings, which applied basic appellate preservation principles. That at the time a judge makes a ruling, a trial judge is entitled to know the pertinent facts with regards to preservation. Here at the motion for entry hearing, Mr. Moss did not ever tell Judge Semino he did not agree to this agreed judgment. Under DHI holdings, that fact is dispositive. Mr. Moss waived any right to appeal by agreeing to the substance of the judgment and by not objecting at the hearing. So under DHI holdings, the right remedy would be to, or right disposition, would be to affirm the final judgment. There's another basis, and that's based on Mr. Moss's actions. The estate of Crawford and Emerson decisions from this court that we cited in our briefing, when a party signs a contract, like this settlement agreement, that waives the right to appeal, we are entitled to dismissal of the appeal. We would like the court to write on both of those grounds. They are straightforward applications of well-settled rules by this court.
Do you have a specific response to appellant's argument that the rendition was not public?
I do. Appellant's argument confuses the three different stages of judgment formation: rendition, signing, and entry. Baker v. Bizzle expressly affirms that those are three distinct phases, and while in each of those phases is important for different aspects of the appellate rules. Entry is important for example, Rule 306A of the Rules of Civil Procedure, and Baker v. Bizzle emphasizes the importance of entry in public rendition. But the court is very clear, and I highlighted in Baker v. Bizzle, page 293 of the opinion, that there is a distinction, though, between rendition and signing and entry. Rendition occurs when the judge takes any effort reasonably calculated to make the decision accessible to the general public. That is all that's required for rendition. That's the signing of the judgment. The second step is when that document is actually posted on the clerk's website. By its very nature, there is going to be a gap between rendition, signing, and entry. There's going to be some amount of time it takes for the clerk to enter. We've discussed the particulars of this week, these few days that occurred between this signing and rendition, but it doesn't matter. The Supreme Court has been crystal clear those are separate steps. So appellant is comparing apples to oranges when they say Baker v. Bizzle. And I want to, we briefed at length oral rendition. I'm happy to answer the court's questions about that, but I think there's a much easier path to addressing Mr. Moss's argument, and that's the date of the signature. You notice Mr. Moss did not touch on that idea here, and that's because there is no way in which a rendition could be after the January 12th signature date. And the presumption of regularity that this court applied in the Simon v. State decision, that the Texas Supreme Court has...
Does that apply in civil cases too, the presumption of regularity?
It does. The Diamond Offshore case from the Texas Supreme Court applies the presumption of regularity to civil cases.
Okay.
So it's the same doctrine, obviously.
I say it a lot in criminal cases, but
I
I
understand.
haven't seen it a lot in civil cases. Though.
Yeah, Diamond v. Offshore is going to be the best authority I can present to you. It's a fairly recent Supreme Court decision that applied presumption of regularity. And it's an obvious reason that it applies across the board. Litigants cannot get out of the finality of judgments by making up allegations against trial courts. Mr. Moss was sanctioned for doing this already, and that's the only way that he has out of the January 12th signature date. You don't have to take my word for it. I want to point the court to two references. First is the appellant's brief, page 35, where Mr. Moss does not cite evidence the date of signature was somehow after January 12th. It says, upon information and belief, he suspects the date was something different. I also want to point the court to the 19th volume of the Reporter's Record, page 25. This is the recusal hearing at which Mr. Moss was sanctioned for making this allegation. And Mr. Moss's counsel acknowledged, and I quote, "We just don't know facts." It is not an exaggeration to say that entertaining any speculation that the date of rendition was anything later than January 12th will put Texas judges in the crosshairs for any party that wants to reach a settlement agreement. If all that is required is what Mr. Moss has provided the court in this case, that upon information and belief I suspect something was amiss, every party that wants out of a settlement agreement that they came to regret, after obtaining the benefits, like Mr. Moss, of the settlement agreement, that's all they have to do. I think this court should send a clear message in its opinion that that sort of attack on Texas trial judges is not to be tolerated. I think Mr. Moss's actions after this judgment demonstrate why this was made. After this judgment, Mr. Moss filed a motion to recuse, used the recusal proceedings, and this appeal is covered to sell the collateral, the Woodson's Reserve, that was supposed to secure his settlement obligations to our clients. He used some of that money to buy himself an $800,000 home that he's now claiming is his homestead. He's forced our clients, after they were entitled to finality, to respond to 14 different emergency proceedings. And he was sanctioned already for attacking Judge Simoneau and making baseless allegations of backdating judgments. We ask that the court affirm and provide the finality that our clients deserve. Thank you.
Thank you, counsel. Any questions? All right,
Thank you.
thank you. Mr. Taylor, what is your response to his argument about your client having waived the right to appeal by agreeing to the second judgment on January 11th, or not objecting to it?
Oh, in the record? So I'm glad you brought that up. He actually said a lot of things. Mr. Taylor Moss supposedly had 2 lawyers representing him at that hearing, but both of them had pending motions to withdraw. Both of them said on the record, we're not here to take any position on this, and we don't have the authority, Your Honor, to sign the agreed judgment. We can't do anything. So Mr. Moss has to speak on his own behalf, and he gets on the stand, because opposing counsel puts him there, and said, wait a minute, you agreed to this, right? And he said, I agreed to it, not understanding what the judgment amount was. So, but I don't care about what your reasons are. Did you agree to it? He goes, I did. I'm asking for an additional 5 days so I can get new counsel. I don't have counsel right now. I don't understand the consequences. So
Okay.
that's what happened. It wasn't like he just went in and said, yeah, no problem.
Okay.
But I want to get to a much more important point. So my esteemed opposing counsel ran a red light when he told you that the signature on the 12th of January would be the date of rendition. That's absolutely false. And here's why. The Supreme Court last year said, and I will quote, a judgment is rendered when the trial court's decision is officially announced orally in open court, so that would have to be the 11th if it happened, comma, by memorandum filed with the clerk. So there's no memorandum in this case, but if he had issued a memorandum and filed it of record, even though it wasn't a pretty nice judgment that's 30 pages long, that
So
would have been
are you
rendition.
contending that judgment wasn't rendered until the 18th, even if the evidence is that he signed it on the 12th?
Exactly.
And so when does the notice of appeal time start? From the date
So-
of signing?
So the notice of appeal deadline has nothing to do with rendition. My opponent already explained that. There's 3 legs to the stool. There's rendition, signing, and then uploading. And so until it's signed, you don't know what the appellate deadlines are. But the Supreme Court last year, and Justice Evan Young, I encourage you to reread that concurring opinion, he laments that we've got 3 different standards and 3 different things that can happen, because he says it's very confusing. But your point about, well, when did the deadline start for appeal has nothing to do with when was the judgment rendered, because it can be rendered publicly in open court, not signed until a week later.
Yeah, but my point is, his deadline is running for appeal, and after that clock starts ticking, you're saying he gets to withdraw consent to the judgment.
No, Your Honor. What I'm trying to say is this. Because what happened on the 11th doesn't constitute rendition, Supreme Court case on point says that, 2004. Because what happened on the 11th is not a rendition, signing something on the 12th in the privacy of your office is not public. When I was quoting, but I stopped my quote, when I was quoting the case earlier, it says the 3 ways to do it, all 3 ways have to be a public pronouncement. So when you're in the privacy of your office and you sign something, that's not public. It's when it gets uploaded that it becomes public. And so those 2 things peacefully coexist, even though it was signed earlier than it was entered of record by the clerk. So my point is this. If you agree with me, and I'm suggesting the Supreme Court has tied your hands on this, you must obey that decision that says an order granting a motion for judgment is not a judgment. So if that's right, then you cannot conclude as a matter of law that the oral hearing of the 11th was a rendition.
All right, let's say we agree with you on that, but in terms of the difference between the date appearing on the face of the judgment, the 12th, versus the date it's entered on the docket, the 18th, if what you're saying is true, doesn't that open the door for any party to file a recusal motion on any occasion when the date that the judgment appears on the docket is different than the date of the judgment?
No, and here's why. What hit me almost as an epiphany when I was preparing for this argument all week, what hit me is that motion to recuse was a big waste of time. Because the motion to recuse was saying, we can't have Judge Semino decide when he signed the document, because only Judge Semino knows when he signed the document, as if that mattered. And I realized, you know what, it doesn't make any difference, because he signed the document in private, it wasn't public, and so it wasn't a rendition. And so under the Rule 11 case law that the Texas Supreme Court has given us, we withdrew before the agreed judgment was rendered, like it or not.
Are you suggesting the motion to recuse was a baseless filing?
No, I think that they thought my prior counsel, Dylan Russell, great lawyer, he left his firm and now is elsewhere, so I got brought in to help. I think that Dylan Russell thought that the date of signature made a difference. But the more I've thought about it and studying the Baker versus Bizzle case, it doesn't make any difference, because he signed it in private. If he had signed it in public, it'd make a huge difference. And so the problem, if you just study the record, it's in front of you on what happened on the 11th of January. The judge never clearly and unequivocally rendered judgment. You don't even know which judgment he's rendering.
Does it change if on the 12th he was in court in a docket and he signed it in public in court?
It could, but that's not what this record shows. This record shows that it was signed somewhere other than in a public environment. So if you are going to sign something in court, you got to give notice, have everybody there. It's got to be a public hearing. That opportunity was on the 11th, but because of a snafu, they didn't have the right judgment for him to sign, and so they will send it to you later. And then the hearing quit, everybody left. So the public at that moment of the cessation of the hearing doesn't have notice of what happened thereafter.
So under that thought, would every time if you know, judgment is rendered, whether it is or not, and everyone leaves, you would then need to bring all the lawyers and all the parties back the following day just for the signature?
No, because in your hypothetical, it was clear that it was a rendition. Judgment is rendered. That's not what happened here. So what happened here is motion for entry is granted, and that falls right within the Naaman versus Grider case, Texas Supreme Court, 2004. They said an order granting a motion for entry of judgment is not a judgment. That's the difference. Yes,
Counsel, I thought I heard your opponent say that anything that you do that helps advance the signed judgment towards publication counts as rendition. Do you agree with that?
So anything that we say is, I didn't follow your question.
I thought I heard him say that, and this is what I'm thinking of. Say you're in a situation with some electronic signature. You put your electronic signature on there on the 12th, and then you push the button and it gets transmitted to the clerk's office. Under what he's saying, that seems to be, under his definition, rendition.
That's right. There's three different ways this record shows Judge Semino signs documents. Three different ways. One way is what you just said. They use the Odyssey system. That's the software. And there's a template, and you hit sign. And when you hit sign with your clicker, it automatically puts your signature that's electronic, not an actual but electronic signature that you posted many years before. And then it automatically propagates a date to the left. Time, date to the second. So there's no question about when something's happened. He didn't do that here. There are two other ways to do it. One way is for him to do John Hancock, his actual signature. He didn't do that. This one's weird. This one shows a signature that's electronic, but it doesn't have the timestamp on it to the left. And the record doesn't explain how is it that the timestamp
Well, it has
is
the date.
missing. Why?
It has the date.
So it has the date of the 12th, but it doesn't have the timestamp, which if you click signature, it should automatically propagate. So that's something we're never going to be able to answer. I
But
don't
a time
know.
isn't required for a judgment.
I'm sorry, Your Honor?
Is a time required?
I don't think a timer is required, a date is required.
Right, and it
But the point is the date for it to be rendition has to be public.
Right.
When he signed that, it wasn't in a public setting. So it wasn't until the clerk uploaded it that it became public, and that's too late.
Where do I find in the record where, if they're using Odyssey, that they are using Odyssey, and that Odyssey requires or will force the blank date in the judgment to populate with the date and time for that. Where do I find that?
There's nothing in the record that would say that or require that. So there's nothing in there whatsoever. All I'm saying is what this record shows is that there's 3 different types of signatures. One where he does it in his own handwriting, one where he does it and says a date that's typed in, and one where he does it and there is a propagated date from the Odyssey system. Why one was used versus the other, I can't tell you. Those are just what the record shows. But what I can tell you is the date doesn't matter, because there wasn't, if you agree with our first point, there wasn't a rendition on the 11th. Signing it on the 12th or the 13th or the 14th or the 15th doesn't mean squat unless and until it's uploaded in the system, because that's when it's public. And that's what the Baker case teaches us. I read through half the quote, but not all the quote, but he gave 3 ways to do it. And all 3 ways have to be done publicly. And one of the ways, they say, is by actually entering it in the system. And so that didn't happen.
All right, sir. We've heard your arguments. I'll shut you off there.
Thank you.
Thank you for your arguments, both sides. The case is submitted, and you're excused when the court's adjourned.